Hello students, welcome to the lecture on labor legislation and wage administration. And after this lecture, we'll be able to learn the following objectives. Explain the concept of labor legislation and wage administration. Define rational wage policy, objectives, and concepts. Discuss the issues in wage policy. Define the Employees Factories Act, objectives, concepts, scopes, and provisions. Understand the rights and obligations of Employees Factories Act. Explain the employer's obligation and rights. Define the Contract Labor Act and Industrial Disputes Act. Understand Payment of Wages Act. Explain Payment of Bonus Act. Let's start with the introduction. Labor legislation consists of statuses, regulations, and jurisprudence governing the relations between capital and labor by providing for certain employment standards and a legal framework for negotiating, adjusting, and administrating those standards and other incidents of employment. Labor legislation in America has gone through 4 distinct periods. Before the late 19th century, legislative intervention in the master-servant relationship had been extremely rare and episodic, and common law and court policy had long prevailed as the dominant legal framework. However, in the late 19th and early 20th centuries, especially during the Progressive Era, waves of protective labor legislation swept across the country, providing industrial workers with some protection against fraudulently unfair and inhumane labor practices by employers. Then during the 1930s, labor legislation began to focus on the organization of labor, and leadership was taken over by the federal government. Since the 1960s, labor laws have reached far beyond unions and industrial workers, offering protection against discrimination because of race, gender, age, or disabilities. In the late 18th and early 19th centuries, visible groups of gainfully employed artisans and mechanics appeared in increasing numbers in urban and early industrializing centers and seaports. When those workers envisioned their collective interests and organized as trade societies and brotherhoods, state courts suppressed their efforts by invoking a doctrine of common law that defines such activity as criminal conspiracy inimical to the general welfare. During the first half of the 19th century, state courts formulated a new legal framework that viewed the master-servant relationship as a contract between 2 free and equal parties. The old paternalism persisted for resident servants, juvenile apprentices, and slaves, but a new court policy denied wage workers medical care for injuries resulting from an accident caused by a fellow servant or the injured worker himself. The legislative initiative and the occasionally favorable judicial response were only a prelude to a full-fledged reform movement of the Progressive Era, 1897 to 1917. During this period, broad interpersonal and interorganizational coalitions developed, dedicated to improving working and living conditions for industrial and mercantile workers. With labor, especially state federations of labor, as the vanguard, the reform coalitions included liberal churches and ministers preaching the social gospel, settlement houses and charity organizations, muckraking journalists and popular magazines, reform-minded college professors, progressive public officials, and inspectors at bureaus of labor or labor statistics, and pro-labor civic organizations. The term wage policy refers to legislation or government action undertaken to regulate the level or structure of wages, or both for the purpose of achieving specific objectives of social and economic policy. Objectives of a wage policy. The ILO publication has enumerated the following objectives of a wage policy in developing countries: to abolish malpractice and abuses in wage payment, to set minimum wages for workers whose bargaining position is weak because they are unorganized or inefficiently organized, accompanied by separate measures to promote the growth of trade unions and collective bargaining, to obtain for the workers a just share in the fruits of economic development, supplemented by appropriate measures to keep workers' expenditure on consumption goods in step with available supplies, so as to minimize inflationary pressure, and to bring about a more efficient allocation and utilization of manpower through wage differential and, where appropriate, systems of payment by results. Provision of minimum wages in sweated industries. In a country like where laborers are exploited in the sweated industries, the basic need is to provide for safety net wages to prevent its exploitation. According to Turner, the protection of workers against exploitation or unduly low wages remains wage policy's major preoccupation for the underdeveloped areas. Importance and need of a rational wage policy. Wage, as monetary reward, is paid to an employee for the service rendered by him. A sound wage policy should be aimed at social justice, which eventually means that the working class gets its due share. So a rational wage policy must be able to furnish a standard of living and must be able to eliminate the relative poverty. Thus, in the present condition, a rational wage policy must effectively deal with the following components: fixing minimum wages, fixing ceiling in wage incomes, wage structure, price stability. Let us study about issues in wage policy now. Some of issues and concerns faced regarding minimum wages are: norms for fixing minimum wages. The Act does not set out a minimum wage in rupee terms, but just stipulates that the wage be a living wage which is to be decided by each state. The Act stipulates that minimum wage rates are to be revised, keeping in mind inflation. Coverage. In order to have minimum wage fixed, the employment or industrial activity has to be included in the schedule of employments. Currently, the number of scheduled employments in the central government is 45, whereas in the state sphere the number is 1,232. Enforcement. The main problem of minimum wage legislation is poor implementation. The Act empowers the appropriate government, central, state, or local, to fix a minimum wage for workers in unorganized sectors. Poor implementation of MWA does not affect organized workers as much as it does to workers in unorganized sectors. Let us now study the objectives, concepts, scopes, and provisions of Employees' Factories Act. Objectives. There are some basic objectives as to ensure adequate safety measures and to promote the health and welfare of the workers employed in factories, to prevent haphazard growth of factories through the provisions related to the approval of plans before the creation of a factory, to regulate the working condition in factories, regulate the working hours, leave, holidays, overtime, and employment of children, women, and young persons. Scope and coverage. There are some basic scopes as regulates working condition in factories, basic minimum requirements for ensuring safety, health, and welfare of workers, applicable to all workers, applicable to all factories using power and employing 10 or more workers, and if not using power, employing 20 or more workers on any day of the preceding 12 months. Provisions. The main provisions are compulsory approval, licensing, and registration of factories, health measures, safety measures, welfare measures, working hours, employment of women and young persons, annual leave provision, accident and occupational diseases, dangerous operations, penalties, obligations, and rights of employees. Let us now discuss the rights and obligations of Employees' Factories Act. The objective of the Minimum Wages Act is to ensure that a minimum rate of wages is paid to all those who are engaged in wage employment. The state and union governments are empowered to declare minimum wages for employment categories given in Schedule 1 and 2 of the Act. The Act also specifies the structure of minimum wage and the procedure for fixing and revising minimum wages as regular intervals. Rights and obligations. The obligation of the employers, practically speaking, the right of employees. Every worker shall have the right to a. Obtain from the occupier information relating to workers' health and safety at work, b. Get trained within the factory wherever possible, or to get himself sponsored by the occupier for getting trained at a training center or institute, duly approved by the Chief Inspector, where training is imparted for workers' health and safety at work. C. Represent to the inspector directly or through his representative in the matter of inadequate provision for protection of his health or safety in the factory. A worker has the right to claim wages for leave allowable to him under the provisions of the Payment of Wages Act. A worker has the right not to pay any fee or charge for the facilities provided by the employer. Laws related to working hours, conditions of services, and employment. The Factories Act is one of the most important legislations covering the manufacturing sector. The Act provides safeguards for workers to protect their health, provides for safety at the workplace when dealing with machinery, improves the physical conditions of the workplace, and provides welfare amenities. The Act also restricts the hours of work, provides for overtime and spread of working hours, employment for young persons, and places restriction on employment of women during the night hours. Laws related to equality and empowerment of women. The Act, a social welfare-oriented law aimed at empowering women, provides security, both employment and financial, for women employees working in certain establishments, except those dismissed for gross misconduct, since the Act prohibits discharge dismissed during the period or pregnancy, for defined periods before and after childbirth. Let's now move to the employer's obligation and rights. Obligation of employers. Compulsory approval. The occupier of any factory has to obtain prior approval of the state government for the site on which the factory is to be situated and for the construction or extension of a factory. Registration, license, and notice by occupier. The occupier of factory is also required to get the factory registered for obtaining a license for operating it and send a notice of occupation to a chief inspector of factories at least 15 days before he begins to occupy the factory. Notice of change of manager. Whenever a new manager is appointed, the occupier must intimate the inspector and the chief inspector in the prescribed form within 7 days from the date he takes over the charge. General duties as to health, safety, and welfare of workers. Every occupier shall a. Ensure, so far as reasonably practicable, the health, safety, and welfare of all workers while they are at work in the factory. B. Provide and maintain plant and systems of work in the factory that are safe and without risks to health. C. Make arrangements for ensuring safety and absence of risks to health in connection with the use, handling, storage, and transport of article and substances. D. Provide necessary information, instruction, training, and supervision for health and safety of all workers. Employment of young persons on dangerous machines. No young person shall be required or allowed to work on any machine to which applies, unless he has been fully instructed as to the dangers arising in connection with the machine, and the precautions to be observed, and a. has received sufficient training in work at the machine, or b. is under adequate supervision by a person who has a thorough knowledge and experience of the machine. Shall apply to such machines as may be prescribed by the state government, being machines which in its opinion are of such a dangerous character that young persons ought not to work on them unless the foregoing requirements are complied with. Right of employers. The obligation of the employee can also be reckoned as right of the employers. Besides, some more right have been vested in the employer under the Factories Act. Right to carry on the plan of setting up a new factory or extension of an existing one, if no adverse order is communicated to him within 3 months of the application for approval. Right to appeal to the central government against the state government's refusal to grant approval to his application for setting up a factory. Right to retain a child or a young person not holding a certificate of fitness from working in the factory. Right of appeal against the order of the inspector or chief inspector to the prescribed appellate authority within 30 days of the service of the order. Right to demand an application for leave from the workers and a medical certificate when leave is availed on the ground of illness. The Contract Labor Regulation and Abolition Act aims at regulating employment of contract labor so as to place it at par with labor employed directly, with regard to the working conditions and certain other benefits. Contract labor refers to the workers engaged by a contractor for the user enterprises. These workers are generally engaged in agricultural operations, plantation, construction industry, ports and docks, oiled fields, factories, railways, shipping, airlines, road transport, etc. The Act applies to every establishment, contractor, in which 20 or more workmen are employed or were employed on any day of the preceding 12 months as contract labor. Every establishment and contractor to whom the Act applies has to register themselves or obtain a license for execution of the contract work. Registration and licensing. The Act applies to the principal employer of an establishment and the contractor wherein 20 or more workmen are employed, or were employed even for 1 day, during preceding 12 months as contract labor. For the purpose of calculating the number, contract labor employed for different purposes through different contractor has to be taken into consideration. This Act does not apply to the establishments where work performed is an intermittent or seasonal nature. Penal provisions. The Act provides that the principal employer to whom this Act is applicable fails to get registered under the Act, and then such principal employer cannot employ contract labor. Responsibilities. The Act enjoins joint and several responsibilities on the principal employer and the contractor. The principal employer should ensure that the contractor does the following: pays the wages as determined by the government, if any, or pays the wages as may be fixed by the Commissioner of Labor. In their absence, pays fair wages to contract laborer. Provides the following facilities: A. Canteen. If employing 100 or more workmen in one place, and if the work is likely to last for 6 months or more. B. Restrooms, where the workmen are required to halt at night and the work is likely to last for 3 months or more. C. Requisite number of latrines or urinals separate for men and women. D. Drinking water. E. Washing. F. First aid. G. Creche. Maintains various registers and records, displays notices, abstracts of the acts, rules, etc. Issues employment card to his workmen, etc. An industrial dispute may be defined as a conflict or difference of opinion between management and workers on the terms of employment. It is a disagreement between an employer and employee's representative, usually a trade union, over pay and other working conditions, and can result in industrial actions. When an industrial dispute occurs, both parties, that is, the management and the workmen, try to pressurize each other. The management may resort to lockouts, while the workers may resort to strikes, picketing, or garrows. Industrial Disputes Act. An industrial dispute is defined as any dispute or difference between employers and employers, or between employers and workmen, or between workmen and which is connected with the employment or non-employment or the terms of employment or with the conditions of labor of any person. From the point of view of the employer, an industrial dispute resulting in stoppage of work means a stoppage of production. This results in increase in the average cost of production since fixed expenses continue to be incurred. For the employee, an industrial dispute entails loss of income. The regular income by way of wages and allowance ceases, and great hardship may be caused to the worker and his family. Settlement of disputes. The normal procedure for the settlement of the dispute is that the aggrieved party or parties have to report in writing to the Secretary of the Market Committee giving full details of the disputed matter. On the receipt of such complaint, the Secretary, in the first instance, tries to amicably settle the dispute himself, but if parties are not satisfied, the dispute is referred to a panel of arbitrators for decision. The rules and procedures of this understanding shall apply subject to such special or additional rules and procedures on dispute settlement contained in the covered agreements as are identified in this understanding. Payment of Wages Act 1936 is a central legislation which applies to the persons employed in the factories and to persons employed in industrial. This act does not apply on workers whose wages payable in respect of a wage period average $32 a month or more. Since the minimum wages are much higher, this act has become almost redundant in its present form. The Ministry of Labor has already initiated the process for suitable amendment of this act. An act to regulate the payment of wages to certain classes of employed persons, to avoid withholding wages, delays in paying wages, and making unauthorized deductions out of wages. Applicability. Every person employed in any factory, upon any railway, or through subcontractor in a railway, and a person employed in an industrial or other establishment. The state government may by notification extend the provisions to any class of person employed in any establishment or class of establishments. Benefits. The Act prescribes for the regular and timely payment of wages on or before 7th day or 10th day after last day of the wage period in respect of which the wages are payable. Preventing unauthorized deductions being made from wages and arbitrary fines. Penal provisions. Penalties are from $4 to $200. Repeat offenses attract 1 to 6 months imprisonment and fine from $10 to $60. Delayed wage payments attract penalty of $2 per day of delay. Salient features. This act has been enacted with the intention of ensuring timely payment of wages to the workers and for payment of wages without unauthorized deductions. The salary in factories, establishments employing less than 1,000 workers is required to be paid by 7th of every month, and in other cases by 10th day of every month. The object of the Act is to maintain peace and harmony between labor and capital by allowing the employees to share the prosperity of the establishment, reflected by the profits earned by the contributions made by capital, management, and labor. The Payment of Bonus Act was enacted to provide for the payment of bonus to persons employed in certain establishments on the basis of profits or productivity and for the matters connected therewith. The Act applies to every factory as defined under the Factories Act and every other establishment in which 20 or more persons are employed on any day during an accounting year. The Act is enforced through the Central Industrial Relations Machinery, CIRM. CIRM is an attached office of the Ministry of Labor and is also known as the Chief Labor Commissioner, Central, CLCC. Organization. It is headed by the Chief Labor Commissioner, Central. Now in the end, let us summarize what we have learned in this lecture. Labor legislation consists of statuses, regulations, and jurisprudence governing the relations between capital and labor. The objective of the Minimum Wages Act is to ensure that a minimum rate of wages is paid to all those who are engaged in wage employment. The manager of a factory is required to send notice of the fatal and other accidents causing disablement to worker for a period of 48 hours or more. The Contract Labor Regulation and Abolition Act aims at regulating employment of contract labor so as to place it at par with labor employed directly, with regard to the working conditions and certain other benefits. A workman is deemed to be employed as contract labor when he is hired in connection with the work of an establishment or through a contractor.